And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
Just argument from the
Nothing.
defendant.
This goes from maybe probation to are you kidding me in minutes. Question for you. If a defendant wants probation, how much do in-custody behavior and respect for staff matter?
Received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. And looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor.
Source, Court Cam TV. Defense runs the standard play. He pled guilty, wants probation, has family support, a job plan, and swears he's learned from prior prison time. Letters say respectful, hardworking, ready to change. On paper, this is how you frame a second chance. But mitigation only works if 2 things are true. He accepts responsibility, and nothing in the record explodes the narrative. The judge is about to test both hard.
It was in your girlfriend's purse, and you didn't even know her purse was in the car, much less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun,
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's...
Here's the problem. He pled guilty, yet tells the judge the gun wasn't his, girlfriend's purse, didn't know it was in the car. That's a factual defense, inconsistent with a knowing plea. Judges hate this contradiction. Either you admit the elements, or you take it to a jury. Trying to keep the plea and deny the facts torpedoes credibility and guts your probation argument. Would you still consider probation after hearing that?
He's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So...
The prosecutor keeps it blunt. He's failed probation before, got revoked, and his jail behavior screams no respect for rules. Recommendation: impose the agreed cap. 6 years TDC. No theatrics, just receipts. Prior revocation plus fresh misconduct equals bad probation risk. It's the cleanest path for the state. Honor the deal, hammer the sentence.
In several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
I speak on the,
Sure.
the case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed off of my file, but it still shows up. That was not on me. It's somebody.
It's more than one time.
The judge flags a glaring mismatch. Multiple letters call him respectful, yet the jail logs describe targeted sexual misconduct toward female officers and repeated defiance. That gap matters. Judges weigh character letters against observable conduct under supervision. If your real-time behavior contradicts your paper halo, the halo loses. This is where probation hopes usually die.
So let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, so another officer, and these aren't the same officers, it's not the same person saying the same thing about you, somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds, had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble.
The court reads dates and details. April 14, refusing bunk orders, cussing at staff. April 7, hand in pants, crude taunts about genital size. March 25, watching rounds, rubbing himself. March 18, laying back, stroking, despite commands. January entries, motions under the blanket, then lifting it to prove nothing. Different officers, same theme. Even if one report was wrong, the pattern is undeniable, and it's aimed at women doing their job. That's disqualifying for community supervision.
January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that day. December 29th, another issue of not following the rules. December 17th, another infraction for...
He denies it all. I sleep on my back. They're making it up. I have a mom and sisters. The judge counters with prison history. He didn't finish 8 years clean. Tattooing, contraband, rule breaking, translation. Under structure, he still breaks rules. Probation is structure plus trust. If you violate both in jail and in prison, why would a judge gamble in the community?
I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal, and you're lucky that this was the agreement. Mr. Smith was generous. The fact is, you could have been enhanced to a second-degree felony because of your history, and you're lucky you weren't.
Decision: the court accepts the plea, finds him guilty, and imposes 6 years, the cap he agreed to. The judge notes he's lucky with his record. The state could have enhanced this to a second degree. She also reads the firearm ammo disability admonishment. Again, it's not personal, it's the law. The bigger message: your in-custody conduct can wreck even a well-packaged mitigation case.
I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Ms. Holmes.
Bottom line, you can't ask for grace while harassing staff and denying facts. The letter said respectful. The record said otherwise. The judge chose the record. Do you think 6 years was fair under the cap? Or should the judge have rejected the plea and gone to trial? Tell me below, and if you want more no BS courtroom breakdowns, like, share, and subscribe. New cases every week.